Group of 10 clauses, and in that group of 10 clauses, there is one amendment by Senator Claude Carignan on Clause 2. Yes, Senator. And Clause 2 is, I understand, on page 3 of the bill.
Exact. Donc, je propose que l'article C40.
Therefore, I move that Bill C-46 be amended in Clause 2 on page 3 by adding the following after line 10, which is that before a regulation is made under Section 253.1 in respect of a drug concentration for a drug, the Minister of Justice and Attorney General of Canada shall cause the proposed regulation to be laid before each House of Parliament, along with a report setting out the scientific evidence that demonstrates the link between impairment and the proposed blood drug concentration. A proposed regulation that is laid before Parliament shall be referred to the appropriate committee of each House as determined by the rules of the House, and the committee shall review the proposed regulation and present a report with its findings to that House within 30 days after the day on which the proposed regulation is referred to it. And as regulation is made, not to be made unless it is approved by both houses, and subsections 1 to 3 apply in the case of a proposed amendment to a regulation made under Section 253.1 in respect of a blood drug concentration for a drug. What this does is that since there is no scientifically established link between THC levels in the blood and impairment, and as we saw, that some people could be users of medical marijuana where they have residual amounts in the blood and therefore might find themselves contravening the law because this has been identified. The minister herself justified the fact that using a regulation because we don't have a scientific basis on which to base this offense. So the effect of this amendment would be to suspend the regulation that creates the limit until such time as the government will come to a conclusion and that they can say, we have the scientific evidence and we can establish it, and at that point in time the regulation should be laid before both houses of Parliament. Because at second reading I pointed out that it's rather unusual for a criminal offense to be created through a regulation rather than through something that's being passed in both houses, and with all of the publicity that comes with that. So the intention here, practically speaking, it would suspend the adoption of the regulation for the limit that is set out until such time as the government will be able to prove the scientific basis for it, and that it would be laid before Parliament. Thank you, Senator. Senator Gold.
Honourable Senators, I'm going to oppose this amendment. I think respectfully it misrepresents the nature of the scientific uncertainty that witnesses have testified to. The proposed limits are based upon the best scientific evidence that is available to the government. Furthermore, based upon the experience of other countries, based upon recommendations of the driving committee, Drugs and Driving Committee. This amendment would have the effect of denying to our law enforcement officers an additional tool necessary to deal with the problem of driving after consuming drugs. All scientific evidence demonstrates that drug use impairs those motor facilities and cognitive faculties relevant to driving. The per se test required a standard. The standard was based upon the best scientific evidence and the experience of other countries, and it's the prudent thing to do going forward. So I will oppose this amendment.
Senator Batters, followed by Senator McIntyre.
At the same time, we also have heard the minister herself talking about the science involved here being not involved, not exact. And we've had testimony from witnesses talking about how chronic users of marijuana have a substantial amount of cannabis level still remaining in THC level, still remaining in their system 1 month after not consuming any further marijuana after smoking a joint 1 month prior to that. So I think those things need to be remembered in this context, and I will be supporting this particular amendment.
Thank you, Senator. Senator McIntyre.
Well, I'm in favor of Senator Canignan's recommendation here. And the reason for that is I think it's become very clear that the testing, evaluation, and the approval process for drug screeners is not in place before being approved by the Attorney General. Witnesses who have testified before this committee were, for example, we all remember Trevor Bushing and Rachel Huggins. Mr. Bushing, as I recall, made it very clear, look, the process is not ready yet. There's no publication in the Royal Gazette, and the screeners have not been approved by the Attorney General. We've also heard from the Chief Superintendent Alford, who is the Director General, National Forensic Lab, and Mr. Alford made it clear that the labs, there will be a significant increase in workload for drug impaired service requests. With the introduction of roadside testing, there will be an increase in the requirement for pretrial technical and scientific support by forensic toxicologists to prosecutors. There will be an increase in the number of requests for court attendance by forensic toxicologists. And in other words, their hands are full, and I think Senator Carignan is a good amendment because he makes it very clear in there that the regulations have to be clear by both houses, by both the House and the Senate, and the regulation is not to be made unless it's approved by both houses of Parliament. We're not just ready for the screeners. We have to clear that first.
Thank you, Senator. Any other comments? Senator Dupuis.
J'aimerais ça comprendre l'amendement.
I'd like to understand the amendment. Are we saying, do I understand correctly, that we're introducing the concept or the idea that any regulation, any draft regulation, will have to be laid before each House of Parliament as if it was a bill, and that therefore be debated and voted upon in both Houses of Parliament as if it was a bill? Is that what I understand correctly? Well, it's not any draft regulation. It is the one that it is concerned or that is targeted in 253.1. And we're saying that the regulation should be studied by the committees of both houses within a certain time frame, so within 30 sitting days after the day on which the proposed regulation is referred to it. And that it can only be made when it is approved by both houses of Parliament. And the committees that would recommend the adoption of that regulation. So, well, I'm trying to understand that because that seems to me to be a new way of proceeding. So I'm trying to understand, with the existing committee, would there be a joint committee that would be, that exists. There's a joint committee that examines all regulations. So we are introducing something new here, a new process. There would be two new committees. Well, no, it would be the relevant committees of each chamber. So this is not regulations. The Regs Committee makes sure that regulations that are passed are in line or in compliance with the laws, and so make sure there's no incongruous elements, and that's not the same as here. Here, the Senate could give the mandate to the appropriate committee, which I think should be Legal and Constitutional Affairs, to make recommendations, whether positive or negative, on the draft regulation, taking into account the scientific data that exists at that point in time. Okay, that's what I understood. So, but that means that we are introducing a new kind of draft regulation, because the normal procedures is that the bill goes before the House, it's passed, and then regulations are created by the executive, by cabinet, and we are, if I understand correctly, introducing a different category, if you will, of regulations, super regulations, that would mean it appears to me that this would be a precedent. Well, it remains to be a regulation, and it's a decision of the governor and council, but the process for its adoption would be to consult both houses. And I don't know if you saw anywhere where some kind of offense, criminal offense, is created through a regulation. So this is that doesn't involve the consultation of both houses. So normally legislation that's passed in the regular parliamentary process is how an offense is created. Yes, but with if we're talking about this regulation, it's almost like saying, is that what we want, or I'm not sure. But what you're saying here is that it has to be passed by it has to be approved, rather, by both houses. It cannot be made unless it is approved by both houses of Parliament. That's not a consultation. That is seeking approval. So we're creating a new category of regulation here. No, well, the appropriate committee of each house, as determined by the rules of that house. Yes, but I'm trying to understand what your draft regulation is here. The regulation cannot be made unless it is approved by both houses of Parliament. So once the appropriate committee is sent, it is sent to, it might be the Social Affairs Committee in this case. Yes, that's possible. All right, so let's say each of the committees studies this for each house. That means that then they report to their respective houses, the House of Commons and the Senate. There's a vote in the House, there's a vote in the Senate on a government bill, or rather on a government decree. So, yes, I'm telling you, you understand. Thank you. Perfect.
Senator Gould, do I see you, Senator Omidvar? Yes?
And this is choppy waters for me, but I'll put it notwithstanding, Senator Carignan. Is there a precedence for this kind of super regulation?
Demander au... Oui, il y a un précédent. Peut-être M. Bédard.
Perhaps Mr. Bédard, Ms. Bédard, could respond to that.
You know, something so new, but we shouldn't, we won't. Let's go.
Oui, donc il y a des précédents.
So there are precedents, the Official Languages Act, the Firearms Act, and there are others. If you want to have more specific examples, we could ask for them to be sent to you.
Thank you, Chair. I won't repeat myself. I think the effect of this would be to unduly delay to the bill and put Canadians at risk. But I do also think that some of the explanations given for it are not based really upon the science and the testimony that we heard. It's true that chronic users may have a certain level of cannabis in their blood long after they have consumed, but you cannot be required under this bill to take a blood test unless you have, in fact, reasonable grounds, which is established by the oral testing at the side, which is set at 25 nanograms, which means that you would have had to have consumed quite recently. So unless you are unless you are driving with in a way that suggests that you are impaired or you have recently consumed, there would be no legal basis for you to take a blood test, and therefore no basis upon which you could fail the per se offense. So again, I oppose this amendment. It's unnecessary, and it would actually put Canadians at risk.
Senator McIntyre.
Okay, we're dealing with three levels of evaluation. And as we all understand, those evaluations will not be codified. They'll be set by regulations. So that's why I think the regulations are very important. If you take alcohol, for example, you know, if you have 80 milligrams of alcohol in 100 milliliters of blood, you're impaired. It's just as simple as that. And here we have 3 levels, very important levels, 2 nanograms and then 2 to 5 nanograms, and then a mixture of nanograms and alcohol. So if we're not going to codify this, then I think the regulations are very important, and this is why I support this amendment, and it should be approved by both houses of Parliament. At least that's my opinion. We did it for alcohol. Why don't we do it for drugs?
Are you ready, honourable senators, to the vote? I don't see any other senator. All those in favour of the motion or the amendment introduced by Senator Carignan, would you request a roll call, Senator?
No.
Well, then by show of hands, honourable senators would want to vote by a show of hands on the amendments? Sure. Okay. All those in favour of the motion introduced by Senator Carignan, please raise your hand. All those opposed? Pardon?
Inaudible, please. Senator Boniface was left and has been replaced by Senator Pate.
All those who abstain?
Non, j'aurais besoin des oui, qui sont
Oui.
contre.
All those opposed? Sorry. All those who abstain? I do. So, you're sure it's 5? No. Senator Munson has voted within.
Don't touch my
No,
foot.
it says voted, wait, 6. Right. So the amendment is defeated. 6 to 5.